Well, let's see. Trying to prompt. Are you sure it's? Well, we're trying to notify them. Oh, there he is. Yeah, they're getting logged in.
All good?
Yes, sir. All good. I think we're good now.
Sorry
Can you
about
stay
that.
in here? Is okay.
Yes, sir.
All right. This is cause number CR 2156, State versus Robert Cecil Crane Jr. And we are set for pre-trial today. Mr. Crane, can you see Mr. Knoll on your screen there?
Yes, sir.
Okay, excellent. All right. Go ahead, Mr. Knoll. Any update for the court? Any announcement on pre-trial?
Hey, John, on pre-trial, I think the recordings that we couldn't get to work, they're probably available. I just need to make sure that they are working. When I called the Wood County District Attorney's Office this morning, I spoke with Brandon Body. He indicated that there had been a examination of Mr. Crane to determine his competency. He indicated to me that that has been returned and that he is competent, and that it would be set on what he called a status docket in the, I believe it's the 402nd District Court up there, June the 10th. And I think what he indicated to me that he didn't believe there'd been any plea offers made on the, I believe it's 3 cases pending in Wood County, because they were waiting on the competency issue. So I would assume between now and hopefully June 10th, there will be some movement, at least on that. Obviously, I have no idea. I know no facts about the cases up there. Other than 2 are assault on public servants, but the other case, I don't know anything at all about. We haven't discussed that. So I guess on a practical basis, I'd like to have this case not set again until after they figure out what they're doing with their 3 felony cases in Wood County.
Okay. Is there any objection from the state if the court sets this for July?
No, Judge.
All right. Mr. Knoll, are you available either July 5th or July 7th?
Let's do July 5th. I'm not a big firecracker guy, so I should probably be available.
Okay.
July 5th.
All right. We'll set this for, do you need it to be another pretrial or a docket call is fine?
If I could just have a pre-trial for 1, to make sure the recordings work, and 2, to see exactly what they're doing, if anything, at that point in time on the Wood County 3 cases.
All right. Court will set this for an additional pretrial on July 5th, and that will be at 1:30. And we'll set up another Zoom with Wood County if Mr. Crane is still in their custody.
Okay. Thank you, Judge.
All right. Thank you, Mr. Crane. We'll tell the detention staff there at the Wood County jail I appreciate their help. Thank you all very much. Appreciate it. Is that all you have this afternoon, Mr. Knoll?
I believe it is, Judge, unless there's something that got away from me there. I think that's it.
Let me double check, but I think you're right. It's all that I see. So you have a good week. You have a good, I almost said weekend, but I don't see you between now and Friday. Have a good weekend.
You too, Judge. You too, Hillary. Bye-bye.
All right, Deputy McLeish, I'm ready when you are, if you have others that are ready.
Yes, sir. Mr. Weiner? Okay. Mr. Weiner, Mr. Fur?
Jeffrey Fur, Judge. It's a plea.
All right, this is cause number CR 27-8, State versus Jeffrey Daniel Furr. And Mr. Weiner, can you give me the terms of the plea agreement?
Yes, Your Honor. This is the one where I was retained on an older case. Mr. Furr has several new cases that I was not retained on. This will resolve all his business in Van Zandt County. The case that I was retained on, which is a 2017 case, is a theft of 2,500 or more, but less than 30,000. It's a state jail felony enhanced to a third-degree felony. The state is reducing it back down to a state jail felony, sentencing him to 12 months, and he has 365 days or 12 months time served on that state jail sentence. If you'll recall, this is the case that the state has not, the new cases had not been received by the state. They can't seem to generate a response on that. And so what they're going to do is ask the court to grant him a PR bond on those new charges. And then they've put in the judgment of my case that they will decline those cases if and when they're ever presented to the district attorney's office. There is a $3,000 fine, and then there is reimbursement fees of $160. And I believe that's the entirety of our agreement, Judge. Essentially, he's being time served on this, granted PR bonds on the new case the DA's office has requested but does not have, and they've agreed to decline them if and when they're ever turned in.
So 12 months state jail, 365 days credit, $3,000 fine, 160 reimbursement, 290 court costs.
Much quicker than I did it, yes, sir.
Okay. And it was enhanced up, but they're going to abandon the enhancements and it's going to remain at the state jail level.
Yes, Your Honor.
All right, Mr. Furr, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. And Mr. Furr, you could probably do this plea better than I could. You've been convicted so many times, and you have gone through this process so many times that I probably could just remain quiet, and you could do this whole thing yourself, couldn't you? I know the answer is yes. You know that the answer is yes. I want you to answer my questions. You're currently represented by Mr. Justin Weiner. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Weiner, do you believe that Mr. Furr is competent today to enter into this plea agreement?
I do, Judge.
You've explained to him all of his legal rights,
Yes, Your Honor.
and you believe he understands them.
Yes, Your Honor.
Mr. Furr, you're charged by indictment with a state jail felony offense of theft of property greater than or equal to $2,500, less than $30,000. As you know, a state jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC and a fine not to exceed $10,000. You understand the plea agreement. You heard Mr. Weiner state that. So understanding the plea agreement, understanding the range of punishment, how do you plead to that offense?
Yeah.
Pleading guilty because you are guilty of committing that crime.
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Weiner, any objection to the offered state's evidence?
No objection.
All right, the offered evidence is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Can you go ahead and give me the summary of facts to support the plea, Ms. Heisel?
Yes, Your Honor. The Van Zandt County Sheriff's Office was contacted by, let me get the name right, Texas Wholesale Tire, a local business, who stated that one of their work trucks full of tools had been stolen from their location. The Sheriff's Office responded out there. The owner indicated that he had surveillance video and that he believed that the suspect seen on surveillance video was the defendant who he knew from past encounters. Law enforcement also had knowledge of this defendant. They pulled previous bookend photos confirmed with the surveillance video that was pulled and was able to affirmatively identify the defendant as the person arriving on scene on foot and then leaving in that vehicle. The vehicle was later recovered in Dallas. The vehicle itself was a 2004 Chevy Silverado pickup truck. approximate value $10,000, and then the value of the tools that were loaded onto that truck were approximately another $10,000 in value.
Thank you, Ms. Heisel. Any objection to that summary, Mr. Weiner?
We have no objection, Judge.
All right. Mr. Furr, based on the evidence, I'm sorry, anything further, Mr. Weiner?
No, I just want to make sure the state was going to file. I don't technically represent him on the new case, but it's my understanding the state was going to get something to the court today for those PR bonds.
Ms. Heisel did, and I've said.
Okay, thank you very much. We have nothing further.
All right, then based on the evidence as presented, the court will follow the plea agreement between the defendant and the state. Court hereby finds that Mr. Jeffrey Daniel Furr is guilty of theft of property greater than or equal to $2,500, less than $30,000. Court assesses his sentence at 12 months confinement in the State Jail Division of TDC. Court awards him 365 days credit towards his sentence for the time that he spent in jail on this cause. Orders him to pay a $3,000 fine, $160 reimbursement fees, and $290 court costs. Mr. Furr, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to see Deputy McLeish to be fingerprinted. And unfortunately, I mean, I hope I don't see you again, but I'll probably see you very soon. Go get fingerprinted.
Judge, that's all I have. May I be excused?
Yes, thank you, Mr. Weiner.
Thanks, Judge. Good to see you.
Mr. Schmidt, you have it.
Mr. Schmidt, who do you have with you?
Avery Plunkett, 41268.
This is cause number CR 21268, CR 21269, State versus Avery, Darien, Plunkett. And is it my understanding we're doing a plea on Mr. Plunkett's cases today?
Yes, Judge, we're going to be pleading on CR 21268. The state's dismissing 269.
Okay, and what are the terms on 268?
Judge, upon a plea of guilt, the state's recommending that the defendant's sentence be 5 years TDC, $2,500 fine, forfeiture of the seized weapon, 1245, a slew of unfiled DA cases, as well as a dismissal on that 269 case.
290 court costs. Does he have any credit?
Judge, he does have 271 days credit. That was a question that I raised with Ms. Heisel and Ms. Abney earlier. Mr. Plunkett believes that he should be entitled to credit from June 26 of 2020. It appeared 2021. Sorry, Judge. It appears as though Mr. Plunkett was in Dallas County custody at that time. It looks like he sent notice to this county. The DA's office doesn't have record of it, and I think all Nicholas Bell bonds went off his bonds in September. So we understand. I've explained to Mr. Plunkett the explanation that the DA's office has provided based on their records. But I would just note for the court that he believes that he should be entitled to 3 months additional credit, give or take.
So is this an issue you're asking the court to decide?
Judge, I just want to note it for the record at this point in time. I do know that because this is a plea to TDC will evaluate his credit time as well. If we can find documentation that is not in the system, because I know that Ms. Abney's already looked for it, then we might ask that the court entertain a revise or judgment with that additional credit time. We're going to look into that.
State, do you have any additional information?
Judge, this was the only time credit that we were able to confirm. Ms. Abney did check several different systems. If we are provided with documentation that shows additional credit time is due, we would not be opposed to a NUNC to address that issue. But at this time, that's all we can find that is not while the defendant was on bond on this charge. We've given him time for all the credit time that he was in after his bondsman went off the bond.
When do we show that our charges here were placed on Mr. Plunkett in Dallas County?
Judge, let me read you exactly what Ms. Abby said. She says that she has 8/28/2020 to 10/2 of 2020 when he bonded out. And then Mr. Nicholas with Roy Brockway went off the bond in September of 2021. And then he's had continuous credit since then. So I don't show that we have record of anything before August of 2020.
And in the clerk's file, it appears that the capias was issued to the sheriff's office and then executed on, let's see, capias sent to the sheriff's office on September 3rd of 2021. Just a moment here. It shows to be executed February 22nd. Of 2022. And so, Mr. Schmidt, you said that Mr. Plunkett sent a letter or something to the county, to Van Zandt County?
It's my understanding that it was documented. We'll confirm what the documentation is, but it should have been, he was in custody in Dallas June 28th. He was originally on bond on these cases, but it's my understanding that the county should have had notice sometime contemporaneous to that June 28th.
So the June date you said?
Yes, sir. June 28th, 21.
I don't see anything in the record that would suggest that. So if upon additional investigation, you find that he is legally entitled to it, then bring that to my attention and we'll get it addressed.
Yes, sir, I will. Other than that, we're ready to proceed.
Okay, Mr. Plunkett, if you'll raise your right hand. Mr. Plunkett, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. So, Mr. Plunkett, before we go through any of the other parts of this plea, you understand the issue with the credit time?
Yes, sir.
And you still want to go forward today, even though you believe that you are entitled to more credit time? Do you still want to go forward with the court's judgment today, having 271 days credit, or do you want to wait until that issue can be finally determined before you plead?
I want to continue.
Want to continue? You sure about that?
Yes, sir.
Okay. All right, Mr. Plunkett, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today with Mr. Schmidt that you do not understand?
No, sir.
Mr. Schmidt, do you believe your client to be competent?
I do, Judge.
And you've explained to him all of his legal rights?
Yes, sir.
And you believe he understands them?
I do.
All right, Mr. Plunkett, you are charged by indictment with a third-degree felony offense of unlawful possession of firearm by felon in CR 21-268. A third-degree felony carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And you heard Mr. Schmidt read the plea agreement, is that you're going to plead guilty to that. The state's going to recommend to the court that your sentence be set at 5 years TDC along with a fine, court costs, your credit time, and they would be taking into consideration all of the other cases listed there in the paperwork, and they would also be dismissing CR 21269, the aggravated assault with a deadly weapon. Is that that's your understanding of the plea? That's what you want the court to approve?
Yes, sir.
Okay, all right, Mr. Plunkett, understanding all of that I've explained to you, how do you plead to unlawful possession of firearm by felon?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. If Mr. Schmidt would just confirm for me that he does have that motion to dismiss there. If he doesn't, I will make sure that gets e-filed. I just wanted us all be on the same page about where the motion to dismiss was.
It's in my, not been signed by the state yet, nor have the other plea paperwork, but I do have it in this packet.
Perfect. I will make sure it's signed before I leave today. Thank you, Mr. Schmidt. State would rest and close, Your Honor.
Anything further from the defense?
No, Judge.
All right, Ms. Heisel, can I have a summary, please?
Yes, Your Honor. Mr. Plunkett, significant other, called 911 alleging that he had pointed a firearm at her. When police get on scene, she makes them aware that Mr. Plunkett is fleeing the scene, and that the firearm that he used in the commission of that aggravated assault is in a backpack he is wearing. The officers stop him for questioning. They search him for officer safety based on the allegation of a firearm. They do find a firearm in his backpack matching the description of the alleged firearm used in the aggravated assault. Mr. Plunkett had, I believe, just been released from parole on a previous penitentiary trip and was not outside of that 5-year requirement for unlawful possession of a firearm by a felon.
Thank you, Ms. Heisel. Mr. Schmidt, any objection to that summary?
Judge, I would say that although I don't have an outright objection to the summary, the allegations that brought law enforcement on the scene was indeed a domestic. Obviously, we've disputed any assault or domestic assault related to the initial allegation. I believe that the state has agreed with us, obviously, because they're filing a motion to outright dismiss that. However, I would state that based on that, they did make contact with Mr. Plunkett and ultimately searched a bag that he had, and there was a firearm present. So substantially, and I know that's what the initial law enforcement report stated, but with that caveat, we would have no further objection.
All right, thank you, Mr. Schmidt. All right, based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Plunkett. Court will follow the plea agreement in this case. Court convicts Avery Darien Plunkett of unlawful possession of firearm by felon, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,500 fine, $290 court costs. Court awards Mr. Plunkett 271 days credit towards his sentence for the time that he has spent in jail on this cause. Court also dismisses CR 21269 and will take into consideration all of those unfiled cases as referenced in the judgment. And the court will also order a weapon forfeiture of the weapon seized in this case. Mr. Plunkett, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over with Deputy McLeish to be fingerprinted.
Judge, one last thing. I did file a pre-contract motion that's attached to the papers just for the court's awareness. So.
Okay, thank you, sir. I appreciate it.
Oh, yeah, thank you.
I'll give you this. All right, Ms. Chester, who do you have with you?
Mr. Fulco.
All right, this is cause number CR 2219, State versus George Walter Fulco, and we are set for pretrial.
That's correct, Judge. We're just asking for one more pretrial setting in this matter. So Mr. Fulco has the chance to review all the discovery that was picked up from the DA's office, including videos. Other than that, we have everything that we need.
Okay. Do you have any contested pretrial motions on file?
Not at this time.
Okay. Do you have any objection to the court just setting it for a docket call, and then that allows Mr. Fulco to review the evidence between now and then?
That's fine.
You don't anticipate any additional pretrial motions coming to light?
Not that I'm aware of at this time, no.
Okay. And if by chance something does arise, you'll just let me know, and we can always set it for a pretrial then.
Okay, perfect, Judge.
All right, court's going to set Mr. Fulco then for a docket call announcement, and we will set that. I believe that we were setting you on what date earlier, Ms. Chester?
The 24th.
24th. All right, we'll do the same here for Mr. Fulco. Docket call on 5/24 at 1:30.
Thank you, Judge. That's all I have this afternoon. May I be excused?
Yes, ma'am. Thank you. All right, Deputy McLeish, I'm going to bring in an online hearing, so it'll be just a moment.
Yes, sir.
Mr. Massar, are you there? I'll leave you a minute for a second, I guess. Let's see. All right, Deputy McLeish.
You ready for us again?
Yeah, I believe so.
Okay, Mr. Adams.
Judge? Judge, can you hear me?
I can, yeah. Who is this?
This is Tom Massar.
Okay, Mr. Massar, can you turn your video on?
Well, I thought it was. Let me see here. Start video, okay. Am I there yet?
Well, no, you're a black screen, but that's okay. That's okay.
Okay, well, it says the host is not allowing participants to unmute themselves.
Unmute.
Yeah, but anyway, but I can hear you, Judge, so I think we're good.
Yeah, on my side, it says that your video is on. I don't know if maybe your camera's disabled. What, it doesn't matter.
Oh, my camera's on, so.
Yeah. It said this is cause number CR 2279, CR 2282, State versus Isaiah Everett Smith, set for arraignment. It's my understanding that Mr. Smith is currently an inmate at TDC.
That's correct.
Okay. And did he just arrive there, or has he been there for a while? Do you know?
He's been there probably right at 2 months now.
Okay. All right. And do you know what his sentence is there?
2 years.
2 years. All right, State, are we seeking a bench warrant to bring Mr. Smith back, or Mr. Massar, are we seeking a bench warrant?
Judge, I think Patty did a bench warrant for us about a month ago when I first contacted the court.
Okay, hang on just a moment. Let me check with her on that. Mr. Massar,
Yes, sir.
Ms. Tabraham says that she informed your office staff that she did not do a bench warrant because he just arrived at TDC from Tarrant County within like the last month. I mean, I'm
Okay.
sorry, within the last week. So,
Oh.
so is there a request by either the defense or the state for a bench warrant?
What, we'd like to dispose of the case, Judge. And so if we can get a bench warrant and there's no rush on it, but we'd like for, he wants to come into court and take care of his case.
And do you two already have, does the state and defense already have an agreement on that?
Not yet, Judge.
No, Your Honor.
Okay, well, perhaps y'all could try to work something out before we bring him back. And then maybe we could even plea him out while he's at TDC without having to transport him.
No, if we could do that, it'd be great.
I'm not sure if this Middleton unit has Zoom capability. Some do, some don't. So we'll have to check into that. So what I'm gonna do is I'm just gonna reset it, and I'm not going to do a bench warrant until I hear something from one of y'all asking for the bench warrant after y'all have tried to determine if y'all can reach an agreement. Because that'll determine how quickly I bring him back. If you have an agreement, we can bring him back quick and get it done. If he's going to request a jury trial, then, I may not set it, soon. We may just set it back a little bit later.
Makes sense to me, Judge.
Okay.
Judge, just for the court's information, looking at the Texas Department of Criminal Justice site, he is already parole eligible on his Tarrant County case. His projected release date is in December of this year. So hopefully Mr. Massar and I can reach some agreement, bring him back and resolve him. If not, it sounds like he will likely be here round about the end of the year.
Okay. Mr. Massar, would you be available June 2nd?
Let me know, Judge. Yes, sir. Anytime you want me.
Okay, let's set this for June 2nd, and we'll do this at 1:30.
Okay.
And we'll check his, we'll set this for arraignment.
Yeah, Judge, I talked to Tom about this about 2 weeks ago in passing, and she said, yeah, we'll get this thing worked out. So.
Okay, well, see what y'all can get done, see what y'all can get agreed, and then what I like to do is when I send that bench warrant out is to know we're gonna be agreed, we're gonna do the plea, we're gonna get him in, get him out, plea him, and get him gone. That way, it's not sitting on my taxpayer books.
Exactly. All right,
Okay.
Thank you, Judge.
You're welcome. June 2nd at 1:30, and then you'll notify us when you need the bench warrant.
Yes, sir. Thanks,
All right.
Tyler.
Yes, sir.
All right, have a good day.
Thank you.
All right, Deputy McLeish, I'm ready.
All right, Your Honor, Mr. Adams.
Mr. Adams is ready.
You want to- Tony, would you like Mr. Manning to go ahead? I thought you were ready.
I'm ready.
Okay.
Still have your pen on.
I won't.
Are you ready on Mr. Adams?
Everyone you have listed on your docket, Your Honor.
And you have them all in the courtroom there with you?
Everybody's present.
All right, we'll just go down the list then. We've got Chandler Chaffee. Is that right? Chaffee.
Chaffee.
Did I say it right? Did I say it right? Chaffee or Chaffee?
Chaffee. Yes, sir.
Chaffee. All right, I'm sorry. I'm sorry about that, sir. All right, Mr. Chaffee is set for pretrial.
Yes, Your Honor. We don't have any pretrial issues to bring up today. And in fact, the state's conveyed a plea offer in this case related to Mr. Chaffee. Mr. Chaffee has indicated to me that today that he wishes to accept the state's plea offer. So I'd ask the court to set us for a plea hearing so that we could make that a reality. It's going to be a plea for probation.
Plea for probation. So the sooner the better, huh?
According to Mr. Chaffee, that's right. Yes, sir.
All right. Do you want to come back? Are you available day after tomorrow, on Thursday?
Bear with me, Your Honor.
I'm bearing.
If it's in the morning time, Your Honor.
Okay. Ms. Abraham says yes. She's approved it.
All right.
So we'll set this for Thursday, and then we'll ask jail staff to bring Mr. Chaffee over at 9 a.m.
That's gonna be the 28th, is that right?
Correct. Rusty Copeland, CR 22-6. Mr. Copeland is set for pretrial.
Yes, Your Honor. We don't have any pretrial issues to bring up today. However, I've not finished going through all the discovered materials in Mr. Copeland's case. I cannot promise the court that I would not have any pretrial issues to bring up. I don't anticipate that I will, but out of an abundance of caution, I don't want to sell myself short and not have the opportunity to do so. So with the court's indulgence, I'd ask for another pretrial setting so that I can wrap up my review of his materials, and he and I can meet and discuss what we're dealing with.
All right, you want May 24th or June 2nd?
If it's gonna be,
Or May 12th, or May 12th.
I'll go with May the 24th. Is it the 24th? Yes, May 24th.
All right, court will set Mr. Copeland then for an additional pretrial on May 24th. That will be at 1:30. And I'm sorry, this is also CR 22-7.
That's correct. That's correct, John.
All right, Shannon McFarlane. Mr. McFarlane is set for pretrial also.
Yes, Your Honor. I don't have any pretrial issues to bring up at this time. I still have some materials that I need to finish reviewing, and I do need to look at the state's CAC interview video. I haven't yet done that, so I'd ask the court to reset a pretrial hearing for us in this case. Give me the opportunity to look at that video and wrap up reviewing the written materials.
All right, court will set Mr. McFarlane for additional pretrial on May 24th at 1:30.
Was arrested on October 18th. Yes, sir.
Mason Pogue, CR 22-76. Mr. Pogue is set for arraignment.
Yes, Your Honor. Mr. Pogue and I, on behalf of Mr. Pogue, he and I reviewed the state's indictment in this case. Mr. Pogue advises me that his name has been properly spelled and set forth in the indictment. He's the same Mason Pogue named in the indictment that is standing here next to me today. He understands the allegation made against him in that indictment. We are going to waive the formal reading of the indictment. At this time, I've reviewed the evidence in the case. I've conveyed just today the state's plea offer in this case. Mr. Pogue told me today that he wants to take that plea offer and wants to get a hearing set to make that happen as quickly as possible. It is an offer for probation.
It's an offer for probation.
Yes, sir.
And is that with your advice or without your advice, Mr.
Your Honor, it's a mandatory probation case unless I'm missing something in a criminal history past that Mr. Pogue says does not exist. I wouldn't discourage her from taking the plea offer. I think that that's where we would head in the future anyway, whether we set this for a docket call or a pretrial. That is based on my experience with these types of cases and what I've seen in the evidence, that's where we would end up anyway.
If I set it on Thursday, like your other client, do you think that'll give you enough time to review the evidence?
We can do that.
Okay.
That'll be fine.
All right, then we will set you for plea on April 28th, and we'll do that in the morning as well, 9 a.m.
Thank you for your indulgence, Your Honor. I appreciate it. I know this is a little unusual.
It's okay.
A little hesitant to bring this to the court's attention, but I wouldn't say I've learned something new today, but I've experienced it.
Well, it's Mr. Pogue's decision, and if he wants to move on it that quick, then we'll do so.
Yes, sir.
Mr. Evers, is that all your clients today?
I think that's all I have. May I be excused?
Yes, sir, you may. Good to see you. Thank you for being here.
Good to see you.
All right, Mr. Manning, are you ready on Ms. White?
Yes, Judge, I'm ready.
All right, this is sorry. I didn't have it written down on here. All right, this is cause number CR 2233, State of Texas versus Karen Juanita White. Ms. White, if you'll raise your right hand, I'm going to place you under oath. Ms. White, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand on. All right, Ms. White, you are represented by Mr. Jonathan Manning. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to go over the state's motion to adjudicate with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Manning, do you believe that Ms. White is competent today?
I do believe so, Judge.
And you've gone over the state's motion to adjudicate with her, explained her rights to her. You believe that she's understood those?
I have gone over the motion to adjudicate as well as explain her rights to her and the consequences of her plea of true.
And does your client waive the formal reading of the state's motion to adjudicate, and does she intend to plead true to all counts?
We do waive, so we do so waive, Judge, we also waive the preparation of the time. As I was just appointed today, I spoke to my client, she wishes to go forward on this plea. And so we waive preparation of any time we may have under the statute in order to go forward with this plea today.
All right, Ms. White, you appeared before the court on September 29th of 2020. You pled guilty to the felony offense of possession of a controlled substance in penalty group 1 between 4 grams to 200 grams. The court heard the evidence in the case, found that there was enough evidence to convict you, but the court followed a plea agreement on that date and placed you on deferred community supervision for a period of 6 years. The court also assessed a $2,000 fine. It's been during that period of your community supervision that the state of Texas has filed a motion to adjudicate and revoke your community supervision. And in that motion, the state has alleged 6 separate counts on ways that you have violated. So at this time, I'm going to ask you, Ms. White, how do you plead to counts 1 through 6? Are those counts true or not true?
You're true. I'm guilty.
Okay, and are you telling me that all of the conduct and behavior alleged in counts 1 through 6 are true? Because in fact, it is true that you did those things, and you're not just saying that it's true so you can get a certain plea agreement.
No, it's true, sir.
Okay. And has anyone threatened, forced, or pressured you to make you feel like you had to plead true to any of these counts?
No, sir.
Court will accept the defendant's plea of true to each count as alleged. Mr. Manning, any objection to the state's evidence?
No objection, state's evidence.
All right, state's evidence is admitted and the court takes judicial notice of Ms. White's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Nothing from the defense, Judge.
All right, based on the defendant's plea of true in the admitted evidence, court finds that Karen Juanita White has violated the terms and conditions of her community supervision. The court, having accepted her plea of true, finds that all counts are true. Court hereby revokes her community supervision, adjudicates her guilt, convicts her of possession of a controlled substance of penalty group 1 greater than or equal to 4 grams, less than 200 grams, a second-degree felony offense. The court assesses her punishment at 2 years confinement in the Texas Department of Criminal Justice, orders her to pay the balance of her financial obligations. Court takes into consideration and dismisses cause number CR 2195, a forgery of a financial instrument, and also ordering her to pay restitution of $593.27 in this case. In addition, court, as her financial obligations, orders her to pay the remainder of the $2,000 fine and $415 court costs. Court also awards Ms. White 109 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. White, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of this sentence. Good luck to you.
Thank you. This one. Judge, will be back.
I'm sorry. Step over there so you can be fingerprinted. I'm sorry, Deputy Probation. I'm sorry, Mr. Manning, you were saying?
I believe that concludes my business. May I be excused?
Yes. You don't have anyone else, right? Oh, we already did.
We'll file waivers on the other two that I.
That's right. Okay. Yes, sir. You're free to go. Appreciate you being here. Mr. Sawyer, are you ready?
Yes, I am.
All right. Is this Mr. McCaslin?
It is, Your Honor.
All right. This is cause number CR22-33, State versus Tyler Buchanan McCaslin. And it's my understanding that we were set for pretrial today, but Mr. McCaslin wants to enter a plea. Is that right?
That's correct, Your Honor.
All right, Mr. Sawyer, I don't have the paperwork with me. Can you read me the terms, including all financials and credit time?
Yes, sir. So in exchange for a plea of guilty by Mr. McCaslin, the state is going to recommend that punishment be assessed under section 1244A of the Texas Penal Code and sentence him to 136 days confinement in the Van Zandt County Jail with credit for 136 days in the Van Zandt County Jail, in other words, time served, a fine of $2,500, court costs of $290, restitution of $180 to DPS for the testing of the substance, and reimbursement of $520.
All right, thank you, Mr. Sawyer. Mr. McCaslin, if you'll raise your right hand, sir, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your hand down. Your name is Tyler Buchanan McCaslin, is that right?
Okay.
And Mr. McCaslin, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Logan Sawyer. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Sawyer, do you believe Mr. McCaslin to be competent today?
I do, Your Honor.
And have you explained to him his legal rights?
I have.
And do you believe he understands them?
I believe that stands all of them, Your Honor.
All right, Mr. McCaslin, you have been charged by indictment with a possession of controlled substance in penalty group 1 or 1B in an amount less than 1 gram. That is a state jail felony offense that would typically carry a range of punishment between 6 months to a maximum of 2 years. However, your plea agreement in this case, as Mr. Sawyer has stated, would be where you would be convicted as a felon, but you would be punished as a misdemeanor. And the range of punishment could not be more than 365 days. And you heard Mr. Sawyer say what the punishment was. It was 136 days. So do you understand the range of punishment in the plea agreement and how that works?
Yes, sir.
And you understand that once we are done here and you're fingerprinted on that judgment, you will be a convicted felon for purposes of this crime.
Yes, sir.
Understanding all that, do you wish to go forward?
Yes, sir.
All right, Mr. McCaslin, how do you plead to that offense?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Sawyer, any objection to the state's evidence?
No objection to Exhibit 1, 2, or any other evidence.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Ms. Heisel, can I have a summary, please?
Yes, Your Honor. Canton PD stopped the defendant's vehicle that he's driving for no taillights eliminated on the vehicle. Immediately, the officer smells the odor of marijuana and asks both the driver, defendant, and his passenger to step out of the car. As he is speaking with the passenger, he sees something out of the corner of his eye. He goes back and reviews his dash cam footage and sees the defendant reach into his pocket and throw something out into the ditch. He gets backup officers on scene. They go and search the area in which they saw him throw the item, and they find a hinged case that has a small baggie of crystal substance and 2 syringes inside. The lab tests the baggie of crystal substance and it comes back at 0.49 grams of methamphetamine.
Thank you, Ms. Heisel. Any objection to that summary, Mr. Sawyer?
No, Your Honor.
All right, then based on the evidence, court finds that there's enough evidence to convict Mr. McCaslin. The court will follow the plea agreement in this case. Court convicts Tyler Buchanan McCaslin of possession of a controlled substance under group 1 or 1-B in an amount of less than 1 gram. Assesses his punishment under section 1244A of the Texas Penal Code at 136 days confinement in the Van Zandt County Jail. The court will award Mr. McCaslin 136 days credit towards that sentence for the time that he has spent in jail on this cause. The court orders him to pay a $2,500 fine, $290 court cost, $180 restitution, and orders him to reimburse Van Zandt County for indigent legal fees in the amount of $520. Court hereby remands Mr. McCaslin to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Mr. McCaslin, once you are released, I want you to report to the Van Zandt County Courthouse and make arrangements to discharge the fines, court costs, restitution, and reimbursements that you owe. We're not asking you to pay it all up front. If you can, that would be great. If you can't, then you need to make out a reasonable payment plan that you can meet each month to discharge these things, because we will monitor it. And if you don't, then the court will issue a warrant for your arrest. Do you understand?
Yes, sir.
Okay. All right. Then go over there with Deputy McLeod. Should be fingerprinted. Is that all you have, Mr. Sawyer?
That is, Your Honor. May I be excused?
You may. Thank you, sir. Appreciate you.
Yes, sir. Thank you.
Have any more attorneys in the jail courtroom?
No, Your Honor, just defendants.
Okay. All right. So let me do a roll call here. Let's see. So we have Mr. Briggs, Ms. Rheem, Mr. Huggins, Mr. Cruz, Mr. Butler, Mr. Turnage.
And Your Honor, we have 2 that are not present with us just yet, and those 2 are Mr. Turnage and Ms. Rheem. All the others are present in the courtroom.
Okay, good. That helps. I will call. I'm gonna wait on Mr. Briggs. He doesn't have an attorney yet. We'll have to talk about that. So Tell you what, let's start with Mr. Huggins.
Come on up, sir.
Give Mr. Green just a moment. He's going to be appearing via Zoom. All right, Mr. Huggins, go ahead and have a seat. Mr. Green's still logging on, it looks like. And I'll recall you just a moment.
Hey, Your Honor, how you doing?
Good morning. Or I'm sorry, good morning. Maybe good morning somewhere. It's not good morning here anymore. All right, it's Corey. Corey Butler. Corey Butler will step on up. Mr. Trainer's ready. All right, Mr. Butler, can you see your attorney, Mr. Trainer, there in the screen?
Yes, I can.
Excellent. Okay. All right. Make sure you speak up loudly and clearly so he can hear you and we all can hear you. This is cause number CR 2262, State versus Corey James Butler. We're set for arraignment today. Mr. Trainer, have you had a chance to go over the indictment with your client?
I have not, Your Honor.
Okay. Give me just a second and I'll pull that up. Mr. Butler, can you see this document on the screen?
Yes.
Can you read all of it? Is any of it obstructed?
Yes, I can.
Okay. All right. Take a moment and tell me when you're ready for me to scroll down.
Go ahead. Go ahead.
All right, Mr. Butler, is your name spelled correctly here in the body of this document?
Yes.
All right, and you understand that you are being charged with a violation of the Health and Safety Code, namely possession of a controlled substance in penalty group 2, greater than or equal to 1 gram, less than 4 grams, which is a 3rd-degree felony. Do you understand that?
Yes.
And the range of punishment for a 3rd-degree felony is not less than 2 years or more than 10 years confinement in TDC, Texas Department of Criminal Justice, and a fine of not more than $10,000. You understand that range of punishment?
Yes.
Now, the state has also alleged 2 enhancement paragraphs that you see there in the indictment. If these are proven true, then the punishment range for your offense, a 3rd-degree felony, would be enhanced to what is known as a habitual felony offender, which would then make the minimum range of punishment a minimum 25 years to a maximum 99 years or life. Do you understand that enhanced range of punishment?
Yes.
All right. And Mr. Trainer, would you like to enter a plea for your client?
Yes, Your Honor, not guilty.
All right. Does he waive the formal reading of the indictment?
Yes, yes, he does, Your Honor.
Okay. All right. The court will find that Mr. Butler has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record, and we will set Mr. Butler for pretrial hearing. Are you available on June 2nd, Mr. Trainer?
That is in right here with Copeland, right where I'm at right now. I believe, would it also be by Zoom, Your Honor?
Let's see, we'd be setting for pretrial. You could appear for pretrial via Zoom if you needed to.
Oh, fantastic. Well, then I can make June 2nd work, I believe.
Okay.
June 2nd. Let me just make sure I don't have a trial or anything that would definitely bar me from being able to do it. And would it be the afternoon as well, Your Honor?
Yes, sir. I call all of my jail cases in the afternoon, and I call my bail cases in the morning.
Okay, perfect. Yes, that will be fine. The 2nd at 1:30.
Okay, we'll set Mr. Butler then for pretrial June 2nd at 1:30. State, have you made discovery available to Mr. Trainer online? Is there any physical evidence discovery that he needs to pick up so that he can have that? What I don't want is I don't want you appearing via Zoom on the 2nd and then saying, hey, I haven't had a chance to go pick up things in Canton, at the DA's office.
Yep, absolutely, Your Honor. I'm actually over here in Copeland right now, so if they do have any of that available, I can head that way to pick it up.
Okay. And State, do y'all have Mr. Trainer listed as the attorney and have discovery turned on for him?
Judge, we do not, and I don't know if Mr. Trainer has contacted our office to be set up on the portal yet or not. I know that he does not have a whole lot of cases out here. So
And I'm familiar if I've done on the portal with y'all. So, are y'all using one of the Tyler ones?
We use LGS.
Okay.
All right, so Mr. Trainer, if you'll make arrangements to make sure that you get any physical discovery videos picked up, then State, I just ask that you make sure that the online portal is provided to Mr. Trainer so he can be available for that June 2nd pretrial. All right, thank you, Mr. Butler. Thank you, Mr. Trainer.
All right, thank you, man. May I be excused, Your Honor?
You may be, yes, sir.
All right, thanks. Take it easy.
All right, Mr. Green, are you ready?
Now I'm ready. I'm unmuted.
Okay. All right, Mr. Huggins, there you go. All right, this is cause number CR 20124. Mr. Huggins, can you see Mr. Green?
Yes, sir.
Okay, excellent. Make sure you speak up loudly and clearly for me. All right, this is a hearing on Mr. Huggins' motion to revoke. Any announcements, Mr. Green?
Judge, you said it today instead of on a contested day, essentially because I have a doctor's appointment this Thursday. I visited with Mr. Woodwick some about possible resolution on this. We have a couple ideas. I need to visit with Mr. Huggins and communicate those to him. I don't know if there's a day in March that we do not have an agreement as of today, although I think we have the potential to get a resolution of it. But I don't know if you want to set that for a contested hearing in May or how you want to try to resolve calendar that for us.
Yeah, usually what I do is if there's no agreement, then I'll just set it on the next contested docket. That's Thursday. I'd obviously set this for May 26th. And then if something gets worked out, you can enter it that day. You can enter it earlier than that time. And if nothing gets worked out, then he's scheduled to have a contested hearing.
Okay. Sounds good to me.
All right, so that'd be May 26th, and that'll be at 1:30, and that will be here at the courthouse. All right, so Mr. Huggins, we'll see you on May 26th. And Mr. Green, if y'all work something out prior to that time, you want to get before the court, then just let Ms. Abraham know.
Thank you, Judge.
You're welcome. Good to see you.
You bet. Can I be excused?
Yes, sir.
Thank you.
All right, do we have Philip Cruz?
Yes, Your Honor.
Mr. Cruz, if you'll come up, sir. All right, this is cause number CR 22-14, State versus Philip Shawn Cruz. Mr. Cruz, can you see Mr. Steele, your attorney?
Yes, sir.
Excellent. Okay. And Mr. Steele, any announcements on pretrial?
Judge, my client was out on bond on this case, picked up some other cases. It's my understanding from talking to Tyler that those other cases will be indicted pretty soon. And so I think the state and I are in agreement to at least reset it one more time and let these other cases get indicted.
Mr. Woodwhack, do we have an estimated grand jury presentation date?
Friday.
Friday? Okay. All right, let's set, we'll need time to, how about June 2nd, Mr. Steele? Can you make that work?
Yeah, June 2nd is great, Judge.
Okay, all right, so we'll set this on June 2nd. That'll be at 1:30. Is that all you have, Mr. Steele?
That's all I have, Judge. May I be excused?
Yes, sir, you can, thanks. Good to see you.
Good to see you, Judge.
All right, and so we need Ms. Rheem and Mr. Turnage. Did I see Ms. Rheem walking in the background earlier?
You
Ms.
did,
Rheem?
Your Honor.
Okay, I thought so. Ms. Rheem, if you'll step on up. This is cause number CR 21366, State versus Tamira Lee Rheem. Ms. Rheem, what do you have going on?
Your Honor, I know the jail agrees with me, medical. I have a shattered hip. I missed court. I'm just gonna be honest with you. I tried to get in touch with Mr. Ashmore. I think he's at his wit's end, not knowing what to do, being my third DWI.
Well, hang on, listen, I don't want you to say anything that may incriminate you, that may affect your case, that I just wanted to know health-wise. I saw you limping. I just kind of want to know what was going on with you physically, but I don't want to hear anything that's case-related, okay?
Sure. Okay, health-wise, my daughter and my aunt are at the courthouse because they thought I was going to court. And they were hoping that if I had a leg monitor or something like that, maybe if you would allow that, I could go into Dr. Babuti at Olympic Plaza, has me scheduled to have hip surgery. I need a total hip replacement.
When is that?
It's a total hip replacement.
No, I said when.
The date has to be rescheduled, but they want to take me straight from here to the emergency room because Van Zandt County says they cannot treat this hip surgery. They know my hip is shattered. They have the evidence and everything, but they can't fix it because I didn't do it here. They said I did it out there. So she said, even the medical lady today said, you know, I hope that you get out today, get your hip fixed. Should anything go wrong, I'm willing to turn myself in, whatever on this DWI, whatever needs to be done, whether I'm guilty or not guilty, I will accept that. But I mean, this hip over here is starting to hurt because this one it's overcompensating for this hip.
Okay. Well, thank you. I do appreciate that. All right. Well, I'll let Mr. Ashmore make an announcement on your case, and then we can talk about that here in just a minute. All right, Mr. Ashmore, this is CR 21366, State versus Tamira Lee Rheem, set for pretrial. Go ahead, Mr. Ashmore.
Judge, thank you. Ms. Rheem, it has, as I understand it, this hip injury, not at my wit's end with anything but the new methamphetamine charge that she's been arrested for, which is why she's in custody. That's my understanding. I don't know if this is a request to, I'll just say this, Judge, I'm not prepared to go forward on any further steps with the DWI 3 case, which we were negotiating to a fair and reasonable resolution, which I believe the court would have approved. But as I understand it, Ms. Rheem has been arrested for a new charge. And I'm going to ask the court to reset that pending indictment so that these two can be resolved concurrently, if that's at all possible, and if the court would entertain that. And of course, if the state would not oppose it, and forgive me, one, for not being able to be there in person. I had a TRO in another county that I needed to walk through. I appreciate the court's accommodation, the state's accommodation, Ms. Rheem's accommodation for my physical absence today.
You're welcome. And so state can you confirm, Mr. Ashmore says new arrest for methamphetamine. Ms. Rheem looks befuddled on that. Can you confirm?
That's not true.
Well, that's okay. I don't want to hear from you, Ms. Rheem. I don't want to hear from you. Okay, I'm not talking to you. I'm talking to the state.
I'm
Okay.
sorry.
Judge, I'm trying to look. The DA's office has not received any information on a new charge, but I am looking, trying to get my computer to load the sheriff's office system, see if I can find if she's been arrested for a new charge of any variety, but it is not connecting. So I do not have any information on any new charges regarding Miss Rheem and a new charge.
Ms. Rheem, why are you in custody? I show that you posted bond with a Springer bail bond. Why are you in custody today?
Yes, sir. I lost my husband last March. In June, this happened. I was overworked and over-medicated. And honestly, the guy that stayed at my house, he called my bail bonds and raised all kinds of crap with her because I told him to get out. I told Mr. Waddell about this. I said, I can't put him out because the judge said I can't because I had to.
Tamira, you are not answering the judge's question.
That's okay.
But the thing is, that's why they went off.
Ms. Rheem,
He's
stop.
asking.
Ms. Rheem,
Yes.
I've answered my own question. You missed court, didn't you?
I missed court. Yes, sir.
Yeah.
I'm sorry.
When I ask you why you're in custody, it's because you missed court.
Yes, sir. I'm sorry. Yes, sir.
Yeah.
Yes.
So I don't know anything about a new charge, Mr. Ashmore, but I do see the Baylor certificate from March. So, okay. All right.
Judge,
so-
I was maybe under the misimpression that there was a new charge and that's why she was in custody. It might just be for bail jumping. So forgive me, but that was my understanding.
Are there any contested pretrial motions, Mr. Ashmore, with regards to the DWI?
No, Judge, I do not have any on file and I do not anticipate that we will have any at all. And I don't anticipate moving for leave to file any.
All right, court will set Ms. Rheem then for a docket call. And are you available on June 2nd, Mr. Ashmore?
I'm pulling my calendar up right now, Judge. Just a moment, please.
Thank you. Thank you. Lawyer.
Yes, Judge. I will put that on my calendar, sir.
Okay, we'll set Ms. Rheem then for 1:30 on June 2nd for a docket call. And if there's any issues with medical or whatever, I'm sure that you'll let me know, Mr. Ashmore, or state.
I will, Judge. Yes, Judge.
All right, Ms. Rheem, we'll see you back on June 2nd.
Okay, Your Honor. And does that mean I'm going home to get my hip fixed?
No, ma'am, that doesn't mean that you're going home to get your hip fixed at this time.
Go ahead and see by the door. Okay, thank you, Your Honor.
You're welcome. Is that all you have, Mr. Ashmore?
That is, Judge. May I be excused?
Yes, sir, you may. Good to see you.
Thank you. Good to see you, sir.
Right, and is Mr. Turnage available?
No, Your Honor, I was gonna wait.
Okay,
We have Mr. Briggs.
okay, all right, Mr. Briggs, come on up. This is CR 2147 State versus Jason Coley Briggs. Mr. Briggs, the state has filed a motion to revoke, as you're aware. That's why you're being held in custody. What is your intention as far as, are you going to hire an attorney to represent you? Are you requesting a court-appointed attorney? You want to represent yourself? What do you want to do?
I'll get a court appointed. I was hoping to maybe get reinstated.
Okay, and have you gone through the paperwork at the jail and asked for a court appointment?
No, sir. I've got the paperwork. I wrote my probation officer trying to see if maybe she might be able to do it. I don't know how that works.
Your probation officer doesn't request lawyers for you.
Okay. Well, I mean, I guess I could fill out the paperwork with a lawyer.
Okay, that's what you're going to have to do.
Yes, sir.
You have to swear to it. It's your statements, not hers or his or anybody else's. Okay. So all I can do now is reset you. I'm going to reset you until Thursday of this week. Okay. So I'll have you brought over in the afternoon at 1:30. So I need you to fill out that paperwork today. That way my coordinator can work on that well beforehand. Okay.
Yes, sir.
So we'll see you on Thursday afternoon.
See you then, sir. Thank you.
Okay, so then that just leaves us Mr. Turnage.
Yes, Your Honor. And if I can have just a couple of minutes, I'll.
Sure. Absolutely, absolutely.
Thank you.
Mr. Turnage, can you see and hear me okay?
Yes, sir.
How are you doing today, Brett?
I'm good.
Doing good? You look good.
Thank you.
All right, Mr. Wood's coming in. He was here. There he is. Can you see Mr. Wood okay? All right, Mr. Wood, how are you doing today, sir?
Good, man. How you doing, Judge?
Doing fine. Can you see and hear Brett okay?
I can see him. I hear him a little bit, but he's a little low, but I can turn up my volume.
Okay, try that. And then Brett, if you don't mind, just speak up a little bit louder so that Mr. Wood can hear you, okay?
Yes, sir.
All right, thank you. All right, this is cause numbers CR 2198, 199, and FC 2015. And there was an application filed by Dr. David Corman to administer psychoactive medication. This is for the purposes of hoping to help Mr. Turnage regain competency so that he can stand trial or resolve his cases that are pending in this court. Mr. Wood, have you had an opportunity to review that and state you as well?
Judge, I have. I had it. I've reviewed it.
Okay. Have you had a chance to discuss it with Mr. Turnage at all?
I have not had a chance to discuss it with Mr. Turnage.
Do you want the court to set you up in a breakout room and give you a chance to talk with Brett about it a little bit before we go any further? Or do you think that's not needed?
We could do that briefly, Your Honor.
Okay. So, Mr. Turnage, what I'm going to do is I'm going to just a second. I'm going to have Deputy McLeish bring you a chair, and you'll be able to sit down there. And I want you to talk to Mr. Wood a little bit about this this application for some medicine. Okay.
I would love to.
Okay. Excellent. Excellent. And then once y'all get through talking, then we'll come back together and we'll all talk about it. Okay. So, Deputy McLeish, are you in there?
Yes, Your Honor.
All right, I'm going to send an invite. Will you just go ahead and make Mr. Turnage comfortable, bring him a chair and let him sit down and adjust it, whatever he needs to do so he and Mr. Wood can talk about this for a second?
Yes, sir.
All right, thank you. And I'm going to set this up. All right, each one of you should have received a link or an invite with it. All right, we'll stand in recess until Mr. Wood, Mr. Turnage have a chance to talk. All right, Mr. Wood, we have an opportunity to discuss the application for psychoactive medications with your client. I've lost you. Let's see. Just a second.
Can you hear me now?
Oh, yes, I've got you now.
Judge, I have had an opportunity to discuss it with him, however, Mr. Turnage is, under the belief that he doesn't need any medication. He is not, willing to take any medication. And he's pretty steadfast in that. And so I don't know what, quite frankly, Your Honor, I've never seen one of these applications for administrating of psychiatric meds before. I have, in looking at it, I think the application process in a situation where you have somebody that is not going to be willing to take medication, who is, in my opinion, suffering from some mental illness, is the concern for me personally. I don't know what capabilities the Van Zandt County Jail has to accomplish that, but quite frankly, that's what is going to have to be accomplished at some point, I believe, with Mr. Turnage. And I don't necessarily know if that's right or fair, or I understand the process. I understand why we're doing it. I just don't know if Mr. Turnage is not going to agree to take medication.
Sure. Well, he can either consent, and if he doesn't consent, then the court would entertain the evidence presented in the application. And if the court found that he, does not have sufficient ability to, make a decision regarding the administration of the medication, then I'd have to find that the medication would be, in his best interest. I'd have to make some other considerations. Less intrusive treatments that are likely to produce the same results, so on and so forth. And if the criteria is met, then it would be, administration, without his consent. So perhaps what we could do, I don't know, what's your schedule like on Thursday of this week? Hang on, Mr. Turnage, I'll call on you in just a second, sir.
Judge, I think right now I'm trying to actually get a case that I've got right now in the office set for plea on Thursday. I don't know if that would be Thursday morning. I would try to get it set that morning. And then the afternoon, I have consult appointments Thursday afternoon.
Do you have any availability around 3 or 3:30 on potentially?
I don't know, Judge. I have some other things that I'd probably like to discuss with you off the record and off of YouTube that are on Thursday. Is there another day that we could do something? Let me check, Judge, real quick.
What about May 12th?
Yeah, May 12th is fine.
May 12th. All right, well, let's do this. We'll hold off on conducting any kind of hearing on this application. That'll give you time to review that more thoroughly and prepare for any position that Mr. Turnage wants to take with regards to the application. We'll set that at 1:30 on Thursday, May 12th. Deputy McLeish, will you unmute the jail so that Mr. Turnage can tell me what's on his mind?
Yes, Your Honor.
Yeah, go ahead, Brett.
Mr. Martin, I'm dealing with the situation on the outside that people are trying to say I'm crazy for, that y'all should be taking an extreme serious look at. I shouldn't be going through this for what's going on the outside. That should be a lot of attention should be on. The people I'm dealing with are serious criminals who have done really serious, crazy things in the yard and all kinds of stuff. And I'm the one that's having to go to a mental hospital for it. To make a long story short, the lady, these people know about all this mental hospital background, and they've done weird things to make me have to be in this situation right here. Now, and my grandma, she's forcing me through this. I can't believe such an insane situation. There's nothing wrong with me. My grandma has always tried to put me in mental hospitals, and these people across the street are doing everything they can to destroy me. And I look crazy for it. And I'm being forced into this situation, and there's nothing wrong with me. If you would contact the Edgewood Police Department and the detectives here, they know the situation. And it's real, it's true.
I understand, Mr. Turnage, but do you understand that the issue regarding the medication has nothing to do with your grandmother, has nothing to do with the people across the street? They're not asking for this. Your grandmother's not asking for this. The neighbors aren't asking for this. No one is asking for this other than the doctor who has evaluated.
He does not know me or does not know my situation. What do I need medication for?
I don't know. I'm not a doctor. I'm not a doctor, and that's why I rely on doctors.
Sir, he's selling drugs. I mean, there's no reason for me to be on drugs. I don't want the drugs sold to me. I don't want it sold to the insurance company. There's no reason for me to be on these drugs.
I understand. Well, we're not going to do anything about that today. So I'll look into what you have to say, and we're going to come back on May 12th. All right. We'll talk about it a little bit more on that date. Okay. So we're not going to do anything about it today. All right. Okay. All right. So we'll see you back on May 12th. All right. Be good. Thank you, Brett. Have a good day. All right, Mr. Wood, Mr. Woodwhy, Ms. Heisel, if you're there, will y'all stay for just a few minutes? I believe that's going to conclude our docket for the day. Let me double check. Make sure I haven't missed anyone.
That's everyone that I show, Your Honor.
All right, so that's going to conclude the docket for today. Court's going to stand in recess and adjourn on the criminal docket until Thursday. So don't forget to hit that subscribe button, that like. Help me get
Smash that like button.
How many followers you got now, Judge?
Leave a follow.
I got
6 followers. That's good. That's good.
I got tens and tens of followers.
Yeah.
Yeah,
I can get my guitar up here, man. I can see what we can do about getting that following list up.
We need to do something because I've only got tens of followers.
And go get no traction, man.
So anyway, y'all make sure you smash that like button and help me get the scribes. Let me get the scribes. So we're going to stop this at this time.